Glenn Douglas, 6 Overlook Ave. I had sent an email, I guess, to the school board about the quorum question. I was curious if you guys got it.
Yeah, we did.
Website,
Yeah,
contact page.
yeah, right. Nate, can you respond? I know you did it. I sent it out. I responded back to you because I had Nate's response on that. I don't know what happened.
Yeah, we were put in it was on the website.
Right.
And if it hasn't been already, it will be put up with a quick link so somebody can get to the trial.
I don't think that's the
No,
question. He's asking
you
about
had
the quorum.
you had a question that you responded and you asked me to send it to
I
him,
sent
which
in
I
a
did.
question about the quorum and the deliberative session in response to Nate's. I have it. I can just read it.
Yeah, why don't you read it? I apologize. You had a response that I mailed to you or emailed to you from work, and I don't.
Apparently, it didn't.
Then it's my fault. I apologize on that.
This was in response to Mr. Greenberg's op-ed on Londonderry NH and in the Londonderry Times. Mr. Greenberg's point that the voters have been presented the quorum question and chose to keep it is valid. There may be a legal argument to be made that the residents should be able to have a quorum if they choose. The fact is, however, that a number of, quote, experts in Concord are indicating that the quorum is illegal. The state has on numerous decisions told the town what they can and cannot do. Does anyone remember workforce housing? The school board should ask the Attorney General's office for an answer specific to the school district charter. Based on the AG's response, the school board and residents can move forward. There is no cost to asking the Attorney General. If the school board does nothing, it seems that there is a potential for a legal challenge. One person standing up at the deliberative session could throw the school district into a tailspin. Worse yet, there's no telling what decision a court would make only a few short weeks before residents vote on the budget and other articles presented at the deliberative session. Like it or not, the question's on the table. How it got there at this point doesn't really matter. Assuming that there is no response from the Attorney General's office is a risky prospect. Let's answer the question and move on. Basically what I'm asking is, what I've read is the Attorney General didn't respond, so we assume it's legal. There's been a lot of chatter on web blogs and here and there. If nothing is done, and the option that seems to be put forward is if someone wants to change this, form a petition, get 500 signatures, whatever. I don't think anyone's going to do that. I think someone's going to stand up at the deliberative session and say, this is invalid, leave the session, go to Derry District Court. What happens? It's 3 weeks.
Right.
Is there a backup plan if someone does that? Because I
One of
know
the-
there's people that are going to do it.
One of the things that I think the issue is, we have a legal charter in front of us. There is nothing we can do at the moment to change anything that would happen in the March election. There has been no injured party in the deliberative session. And speaking with the attorney, and we'll have a letter and we'll post it on the web, we asked the question of a declaratory judgment by the Supreme Court. The attorney does not believe, the way the Superior Court is right now, that would be possible. They wouldn't even approach it because there's not an injured party. So we couldn't go up there, and that was one of the things that's been bandied around, is go up there, ask for a judgment, and then come back and make a decision. We don't have that option of doing it. Our attorney doesn't believe that's it because there's no one arguing against him. And until that happens, you can't get that type of decision. And I'll have a letter, we'll have a letter within several days, and we'll post it on the web to that effect. Okay, so that's the first thing. Go ahead, John.
No, go ahead.
Finish.
I thought you were
finish
done.
It. Go ahead. No, finish it.
Okay.
Go ahead.
There's been the question about asking the Attorney General, and in my mind, the question to that is why? I mean, the Attorney General cannot issue an order on his own. He doesn't have the force, he doesn't have the power of a court. So even if the Attorney General were to turn around tomorrow and come out and say that your quorum is illegal, we as a school board can't do anything to change it unless the voters change it or there's a court order. So asking the Attorney General is kind of a moot thing. There's also the point that the Attorney General historically has been wrong before. Witness the last state education funding bill. So I think that the question of asking the Attorney General is a non-starter because the Attorney General isn't, in a word, the decider. And the question of going for a declarative ruling is a no-go because a court won't look at it unless there are two parties and a case in point.
I can understand that. However, there has been a number of things that have been came out in Mr. Baldessaro's letter. Merrimack brought up the same thing. I went and I read through their minutes. They actually brought up Londonderry by name, a 500-person quorum, sent it to the AG's office, and he said no.
Sure.
I understand. What I don't understand is what disaster do we end up in February?
Well, Glenn, the one thing that I want to say again about that, even if the Attorney General says you can't have a quorum, we are still required by law to honor the charter that exists. The Attorney General cannot change the charter. It takes the voters or a court. Therefore, we have to have the quorum.
I guess, Glenn, what you're bringing up is the issue that we're looking at. And the board hasn't, we're going to have those discussions in the future. There's very little options that we have available to us. That's the issue. We can't go out there unilaterally and change the charter. We can't ask the court to declare it illegal because of it or ask them for a judgment on it. So we're kind of in a box ourselves on what we do with it. And, then you can get into several of the options we have right now is put something on the ballot, have the voters put something on the ballot, go to a lawsuit, and then you can end up as, let's go down one pathway. If we put it on the ballot to go down to 0 and the voters reject it, now, it starts to go down to...
All I'm saying is I'm concerned what happens in February. I know the way things happen in this town. I know what kind of a frenzy this thing will turn into. It's going to be...
Right. But right now, Glenn, there is nothing, according to our attorney, unless there's a smarter attorney out there, that we can do right now to change that situation. That's the problem we're in. And with the voters last March turning down the 350, which I was surprised about, it was just a case to bring us to the same point here that we're not, we've spoken to the attorney, I've spoken to him. There's not a whole heck of a lot of wiggle room here to do something, say the March or the February deliberative session is safe. We can do X and the charter, the quorum goes away.
I think, Glenn, correct me if I'm wrong, but I think what you're asking is, and Reed just happens to be sitting there, when Reed stands up at the deliberative session says, I want to make a motion, and basically he can't because there's not 499 of his friends there, Reed's going to go get an attorney and sue the district. Actually, he'll sue the district, I suppose.
I don't think Reed will, but...
Well, I'm just picking on Reed because he's sitting there, right? Yeah. Somebody out there, so somebody out there would. And I think what your question is, what position are we in at that point? What are we going to do?
3 weeks.
And right.
Are we into a special election and this and that?
And I don't know the answers to those questions. And I think what Ronnie's saying is those are some of the things that we've got out to the attorney. What's our
attorney's going to come back with
what's our fallback position?
Maybe.
It could be Plan Q for all I know. But yeah, it's and I can understand where you're coming from with that. I think that's a valid question.
Nate.
I think it's an important question.
Is I understand. I'm just going to kind of repeat a little bit too and elaborate. Right now, for the sake for our discussion here, the charter is considered legal because it had gone through the process. The school board cannot unilaterally change the charter. That requires a vote of the citizens. The school board can't ask for a declaratory judgment, nor can it ask for an advisory judgment. The only people that can ask for an advisory judgment from the court is the legislature on proposed legislation, not a law that's in there. So the situation then, as Ron had mentioned, there are options. You can put an article on the warrant that says to reduce the quorum to 0, if you want. and that can be voted on. If people vote against turning it to 0, and somebody at school district at the deliberative session says, I'd like to reduce the warrant article for uniforms for football, let's just say for the sake of argument, and they're declared out of order, they can then say they're an aggrieved party and go to court. Now, if it goes to court, and this is all if, and if, what is the timeline in that person going to court and saying that their rights were abrogated because they didn't have a time, and do they ask for an injunction to delay the vote? Does it not get in there on time and you have the vote, and then they only ask on that particular article, or they ask for that particular budget? There are a whole variety of things going forward. Or the board just says, we believe it's accurate as it is legal as it is, which is the position the board has taken, and don't do anything at this point, because legally they can't do anything, and then you go to deliberative session. If someone feels aggrieved, then they can take it to court, and then it wins its way through the court. Part of it would be a timeline as to what happens. The box, as Ron has mentioned, that the school board is in, if you want to call it that, is that unilaterally they can't do it. The board cannot legally ask for a declaratory judgment in and of themselves, and the board cannot unilaterally change the charter. The only thing the board can do is put proposed amendment for a single item, a single article on the charter, and say, do you want to vote on this? Which would not impact this year's deliberative session nor the vote, unless somebody decided they were going to take the school to court. Your point about asking the Attorney General is a reasonable thing for somebody to ask, but the fact of the matter is, even if the Attorney General said, well, I don't think it's correct, or I think it's correct, it doesn't have the force of law. And then the board, even because the Attorney General comes back and says, well, I don't think it's correct, or even if he says he does, the board can't unilaterally change it. That requires a vote of the people, or it requires a ruling from the court. Then, if it goes to court, then you've got multiple steps, because first it would go to Superior Court. And let's say Superior Court ruled in favor of the school board, just for the sake of argument. Then someone could then, if they so chose, appeal that and go to the Supreme Court. And the board could do the same thing if in fact they wanted to do it. So it does create a rather Byzantine situation, for lack of a better term, that we find ourselves in, an issue that was raised by the Attorney General, even though